Hello, good morning students. Please subscribe the channel, drop a like, share and comment. This is Shree Vishnu Art Press Publications, exercise number 3 and 4 on the speed of 90 words per minute. Start. The petitioner was appointed as lecturer in mathematics in the Institute of Engineering and Rural Technology, Allahabad, on 6th September 1983. The petitioner's wife, Dr. Sarita Srivastava, joined as lecturer in Sanskriti in the Rajashri Tandon Mahila Mahavidyalaya on 31st March 1989. Both the petitioners were receiving house rent allowance from their respective institutions till January 1996, when the house rent allowance of the petitioner's wife was stopped by the principal on the ground that she is not entitled to receive the same, since her husband is already receiving the house rent allowance. The petitioner gave in writing that the house rent allowance to the petitioner be not paid, and the house rent allowance to the petitioner's wife be restored with effect from March 1996. The house rent allowance of the petitioner was stopped and that of his wife was restored with effect from March 1996. The petitioner submitted a representation on 17th February 1997 to the Director, IERT, seeking payment of house rent allowance as well as arrears of house rent allowance on the strength of the division bench judgment of this court in the case of Dr. Maya Rani Srivastava versus Director Higher Education Uttar Pradesh Allahabad and others, AIR 1998 SC 157. The petitioner submitted reminders. The Director, IERT, by order dated 5th September 1997, directed for payment of house rent allowance to the petitioner, in pursuance of which the Joint Director, Technical Education, Varanasi, started payment of house rent allowance to the petitioner from October 1997. The petitioner thereafter submitted another representation for payment of arrears of house rent allowance from March 1996 to September 1997. On such representation of the petitioner, the Director, Technical Education, wrote to the state government seeking appropriate direction for stopping the house rent allowance of the petitioner. In the reference letter dated 11th July 2000 of the Director, Technical Education, it was stated that when husband and wife both are residing in the same city and in the same house, both are not entitled for house rent allowance, and the judgment of this court in Dr. Maya Rani's case, supra, cannot be applied in all matters. The state government wrote a letter on 21st October 2000 to the Director, Technical Education, after receiving which letter the Director, Technical Education, issued an order dated 10th November 2000 for stopping the payment of house rent allowance to the petitioner and for taking steps for recovery of irregularly paid house rent allowance to the petitioner and further to submit a report of responsible official in that regard. This writ petition has been filed by the petitioner challenging the aforesaid order. In the counter affidavit filed by the state, it was stated that in view of the clear policy of the state that if husband and wife both are in the government service, the house rent allowance is not payable to both of them. Hence, the order issued were perfectly in accordance with law and the petitioner was not entitled for payment of house rent allowance. In the present case, the respondents in the writ petition had raised a specific plea of delay as a bar to grant relief to the petitioners. In our view, it was perhaps necessary for the court to have specifically dealt with this issue. It is now well settled that a person who seeks the intervention of the High Court under Article 226 should give a satisfactory explanation of his failure to assert his claim at an earlier date. The excuse for procrastination should find a place in the petition filed before the court and the facts relied upon by him should be set out clearly in the body of the petition. An excuse that he was agitating his claims before authorities by making repeated representations would not be satisfactory explanation for condoning the inordinate delay in approaching the court. If a litigant runs after a remedy not provided in the statute, it cannot be a satisfactory explanation for condoning the delay in approaching the court. On this issue, we have heard the learned counsel for the parties in great detail, since the immovable property rights of the parties are involved. In our considered view, there is no explanation, much less satisfactory explanation offered by the respondents in approaching the writ court after an inordinate delay of nearly 15 years from the date of the notification issued under the O.M.S.P. Property Act. For the delay from 1952 to 1955, the contesting respondents would only submit that they were not aware of the notification issued under the O.M.S.P. Property Act, since no notice was served on them, though a public notice was issued by the authority under the O.M.S.P. Property Act. While explaining the delay of nearly 11 years from 1955 to 1966, they contend that they were in possession of the property and they were making representations before the authorities under the O.M.S.P. Property Act for redressal of their grievance. The delay after the orders were passed by the Settlement Commissioner in the year 1983 till the writ petition was filed in the year 1990. It is explained that they had moved the state government suo motu to revise the order passed by the Chief Settlement Commissioner, and since the state government returned their request, They had approached the High Court to issue directions to the state government to issue appropriate directions. In our considered view, there was inordinate delay in approaching the authorities for redressal of their grievance. As rightly contended by Sri Mukund, even when they approached the authorities, they were claiming wrong reliefs or incomplete reliefs. Even when they filed the writ petition in the year 1990, they did not choose to question the correctness of the notification but was questioned by way of filing an amendment application in the year 1998. There is some merit in the submission made by the learned counsel for the contesting respondents that the petitioners had not even offered any satisfactory explanation in approaching the court nearly after 3 decades from the date of notification issued under the Vacui Property Act.